very judgmental
for competency.
Janelle, I'm going to let you go back to your cell. Brandy, you can take her back.
I'm sorry. I didn't mean to.
All right, thank you. Well, that did not go well. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. She jumped on some lady's back and broke her collarbone and said a bunch of racially charged hate stuff.
This sovereign citizen was in court the other day and had a complete meltdown, like full in chaos mode. As soon as a judge mentioned the word jail, she absolutely lost it. This lady was definitely on something, or maybe just naturally unhinged. I honestly don't even know anymore with these sovereign citizens. Let me know in the comments if you think she was tweaked out or if this is just her everyday personality, because I'm honestly stuck between both. Either way, it is one of the wildest reactions I've seen in a courtroom in a while. Let's dive in and watch this sovereign citizen go nuts in court here.
All right, let me start the record. As very often happens, sometimes emergencies come up. The title of the case is People versus Janelle and Anthony. The file number is 241775FY. We have a host of people here. We have the entire public defender team, headed by Keith Stickley. We have Ross Truckee, who's been appointed to represent this defendant, substituting for Paul Gibson. We have Prosecutor David Marvin. This is an emergency motion. My understanding is the defendant was quite agitated at the time of her arrest. In fact, I'll tell you what I know about it. I was arraigning another person, and I called over and they brought a young woman and they said, well, it may take a minute. We've got an unruly person coming from Three Rivers. I think I heard a little ruckus in the background. Well, that person was Janelle Anthony. I was at a meeting yesterday with the undersheriff, and he said she was still quite agitated. She's charged with assault with intent to commit great bodily harm, resisting and obstructing a police officer, ethnic intimidation, 2 counts of assault and battery. So we're about to bring her in. I asked the bailiffs to tell her that Judge Middleton wanted to see her and bring her in. So we'll see how this goes as I bring her in. And
There it is for you. Hi, Middleton.
good afternoon. Miss Anthony, can you hear me?
Yeah.
Okay, this is Judge Middleton.
Hi.
Hi, I wanted to talk to you. I've got a bunch of people here at the court with me. Mr. Keith Stickley, the chief public defender, is here. Your attorney, Mr. Ross Truckee, is here, and prosecuting attorney David Marvin is here. Janelle, I don't know if you remember me, but I remember you from when you were.
I know my dad. I went to school with your son Alex. He was
Yes,
my
I
boy.
remember.
He was a good boy. I liked him.
Well, thanks. He's still a good boy. He just turned 40. All right. You're charged with some very serious charges.
Yeah, they were.
Assault with intent to commit great bodily harm, resisting and obstructing a police officer, ethnic intimidation, and 2 counts of assault and battery. The magistrate set the bond in the amount of $10,000 cash or surety, and Mr. Truckee made a motion, and he wants me to review that bond.
Thanks, Mr. Truckee.
Your Honor.
Yes?
I had the opportunity, sorry to interrupt, I had the opportunity to review the video from yesterday, the arraignment. And the same sort of thing that happened yesterday from my point of view is happening now. I don't know if she's aware of what's going on as she sits there. I don't know if she's on the page. I don't think she heard a thing he said. And I know at any time anybody can make a motion for competency, and I would suggest that she assess for competency.
All right, Miss Anthony? Janelle? All right. Janelle, I'm going to let you go back to your cell. Brandy, you can take her back.
I'm sorry. I didn't mean to.
All right, thank you. Well, that did not go well. Started all right. David, I don't think you helped anything. I was establishing some rapport and then it all sort of went sideways. But,
I don't agree, respectfully.
well, I guess you don't have to.
I know I joke about sovereign citizens being mentally ill, but this woman is clearly not okay. Like, this isn't just your average courtroom clownery. There's something definitely deeper here. I mean, it's just so obvious she's either struggling with some serious mental illness under the influence of something strong, or honestly just both of that. And I'm not trying to roast her too hard, because when it comes to addiction or mental health, I mean, that stuff is real stuff and you never know what somebody's dealing with behind the scenes. So you can't be too hard on them, but at the same time, you can't just come into court acting like you're in a reality show me meltdown and expect the judge to just sit there nodding politely. I mean, I actually agreed with the judge here. He stayed pretty calm considering how wild this hearing got. And it really did look like the prosecutor was poking at her and kind of set her off too, so he was just interrupting and throwing fire on the fuel. And honestly, I didn't like that at all, but let me know in the comments if you think the prosecutor should have been told to chill, because it definitely felt like he was making things worse here.
I had given the floor to Mr. Truckee to make his motion, and you said, I don't want to interrupt, and then you interrupted.
Your Honor, may I say something else?
Yes.
I was looking at the computer screen. I don't know what you were looking at, but I saw somebody who had her head turned away from you and did not hear a word you said. And I don't know if you're looking at the
I saw the same thing you saw.
I would like to inquire, Mr. Marvin.
All right, well, first of all, let's back up. You made this motion. I'll read it. You don't cite any authority. You just made a motion. The reasons for the modification of the bond are failure to effect a proper arraignment on the defendant within 48 hours. There exists an unreasonable delay due to the ill will of the custodial officer during the arraignment hearing. The defendant was under threat or coercion during the arraignment, and the officer's actions jeopardized her constitutional right to make statements freely. Magistrate Autumn Kiefer probably was doing the same thing I'm doing, trying to do the best she could with a mentally ill defendant. And the unreasonable delay is not unreasonable because the delay is due to the mental illness of the defendant. And Mr. Marvin, I think, is on the money that we need to probably have a competency evaluation sooner rather than later. So, Mr. Truckee, what were you asking me to do?
I was asking you to find that the arraignment that was offered and is being tendered as an arraignment within the 48 hours was not a valid procedure, not due to Miss Anthony's unruly conduct or mental illness, but due to the conduct of the corrections officers that were present in the holding room with Miss Anthony. Twice the taser was directed at her head.
Well, look back up. What's your authority for this?
Under MCL 764.13, 764.26, and People v. Cipriano all address the need for this 48-hour period. And it's United States and Michigan constitutions.
All right, well, let's take yesterday off the table for a minute. I just attempted to do an arraignment myself. The bailiffs were gentle with her. She was okay for a minute, and then she disassembled before our eyes. So whatever just happened was not as the result of conduct of the corrections officers. I asked the officer how she was doing. They said she was calmer today, but she had been crying all day. She's obviously suffering from severe mental illness. Problem in today's world is we can't tell how much is mental illness and how much is methamphetamine or both. The current configuration of methamphetamine helps create schizophrenia. So I don't know if that's what we're dealing with or she just is schizophrenic. The charges are very serious. Assault with intent to do great bodily harm. The booking information indicated that she jumped on some lady's back and broke her collarbone, and said a bunch of racially charged hate stuff and fought with the officers, and it was a bad situation. So what you're asking me to do is essentially give her a PR bond or just discharge her?
I'm requesting that she either be granted a PR bond in this case with the understanding that she's on bond in a circuit court case, and that PR bond may not mean her immediate release. But I think in this file, she was denied due process by failing to be arraigned and failing to be afforded the ability to meaningfully participate, even though her participation isn't going to be terribly meaningful. A taser was aimed at her during the arraignment. She was directed how to answer the magistrate's questions. And I don't think that in any way that can be found to be an effective process.
All right. Well, the one we just did was, she's posted bond in the circuit court. As far as I know, there's been no motion to revoke that bond. I don't have the authority to revoke it. She's pled guilty, so she's no longer presumed to be innocent, so she's not entitled to a bond, but she has a bond and she posted it. She pled on the 24th of September, and this incident occurred on September 30th. So I'm not sure what happened between the time she pled in circuit court and the time she got arrested in Three Rivers.
I would indicate, Your Honor, I'm in possession of a complaint regarding her conditional release from Officer Dibble. Due to this alleged conduct, he's seeking that in a circuit court case, and I suspect it would be dealt with promptly.
All right, well, I'm going to deny the motion for PR bond.
I did have an alternative request, if Your Honor would hear it.
All right, what's your alternative?
It may be based on the conduct during the arraignment, request that she be held at a different facility pending trial. It appears that it's unsafe for Miss Janelle Anthony at the jail.
All right, so you make an oral motion on the fly for me to remove her from the jail. So I'm not going to grant that either. I don't know. I have faith in our jail staff. I know all of them. I knew the two ladies in the video. I don't know what happened yesterday. I know what I just saw. But the fact that we're going to get a competency evaluation is going to greatly delay this. And she's going to be sitting there. So I don't know if there's any evidence that she's being mistreated presently. I did talk to the undersheriff about her yesterday. And a couple issues. For the last several years, we've had Covered Bridge as our mental health liaison, jail diversion specialist at the jail. That contract ended September 30th, and a new contract began with Pivotal. And frankly, we've had some bumps in the road. I had asked someone for some help with Aaron Brown, and I made 2 requests last week with no response. Got a response on Lisa's last day, September 30th, and then I sent an email to the director of Pivotal saying, will someone please help me with this guy? He's sitting in jail and he's got some serious mental health problems. And I haven't heard anything back. So right now, mental health is Pivotal, our county mental health. She was apparently capable enough on September 25th to enter a guilty plea I guess it was no contest plea in circuit court, and Judge Stutzman accepted it. I'm not sure, as I stated a minute ago, what happened between then and now. Do you have a position regarding Mr. Marvin's request for a competency evaluation?
I'm not able to take a position on competency at this time. I was appointed to this afternoon. I've got to meet with Miss Anthony before I can speak on it.
All right. I'm denying the motion to amend or change the bond.
And the only further request I have, Your Honor, is that this court review the video of the arraignment.
As I said, I'm not worried about that arraignment. I'm worried about the one I just did.
I understand.
So I'll say I would set a $10,000 cash or surety bond based on the conduct, based on the fact that she was on a felony bond and had pled guilty 5 days before, based on the fact that someone had a broken collarbone. If you want, I will set bond today.
Well, I might end up with a similar objection to this arraignment. But I would note that the conduct here was much different from the corrections officers.
All right, well, 10,000 cash or surety with the same conditions. Greatly against the public interest to put this young woman out on the street, and it's against her interest. There's not a petition for hospitalization. She's on a personal recognizance bond in the circuit court. And if I were to grant your motion, she would be standing on the front steps of the jail in the condition that she's presently in. And I'm not willing to do that. And we're not talking about shoplifting or running a stop sign. She is accused of seriously injuring someone. And there's a public protection interest here and an interest to protect her. And I had this discussion with the sheriff yesterday, acting Sheriff Bingaman. Our jail is the largest mental health facility in St. Joe County. Of the 93 people in there, probably about 40 of them have mental health problems. Some of them are quite acute, and she certainly is. So she's connected to Pivotal. She is in a position where she can't harm anybody. I don't know if Pivotal would petition for hospitalization. They could do a police petition, or someone could petition or hospitalize her. As you all know, once you ask for a competency evaluation, it takes a long time to get there. Mary Finney was in jail for like 400 days before she got her competency evaluation, and she's not competent. So at any rate, the bond is set at $10,000 cash or surety with same conditions. The motion to transfer from jail, St. Joe County Jail, is denied. If there's additional evidence presented that she's unsafe or being unfairly treated at the jail, but she's just going to take her current problems to whatever jail I put her in. There is an option that somebody could petition for hospitalization. Mr. Marvin's motion for competency evaluation. I'm going to take that under advisement. Ms. Anthony is set for a pre-exam conference for October 15th. Anytime before then and now, we can review it. She is working with mental health. I'd like some input from them. She's been like this for 4 days. I don't know that she's instantaneously going to go into remission. I don't know enough about what's going on, but obviously what we all saw certainly begs for a competency evaluation. But Mr. Marvin, I think you made it in good faith. I'll take it under consideration. We can review it again between now and October 15th. And I'd like some input from CMH. Also, Judge Stutzman's going to have a problem. Someone from the Department of Corrections is going to be tasked with doing a pre-sentence investigation report on the case that she pled to, and thinking of a sentence on November 1st.
That could very well result in a report of competency concern.
Yes, he has the same problem I do. So perhaps if there's going to be a competency petition, it could be done in both files. So, Mr. Truckee, you are doing your job that you're appointed to do, to look out for the interests of your clients, but I don't think it's in the best interest of the public or her to grant your motion. We can certainly revisit it. And I'll revisit your motion to move her to a different jail.
This case is going to take forever, that's all I know, unless they hospitalize her and she actually gets the help she clearly needs. I do not see her turning anything around anytime soon. She's facing serious charges. The courtroom energy is tense. And honestly, her behavior didn't exactly scream ready for release, and like I said earlier, let me know if you think she was on something, because I'm definitely leaning towards absolutely, but I don't want to assume anything without facts. This could be drugs or mental illness or both. You just never know these days. And honestly, we are just seeing more and more cases like this pop up where people are clearly not in the right. mental space, but the justice system isn't really built to deal with it properly. I mean, judges aren't therapists and jails aren't hospitals. But still, that's where a lot of mentally ill defendants end up. And when somebody walks into the courtroom talking nonsense or just screaming, it's not always just defiance. There's always, sometimes it's definitely deeper than that. But even when mental health is involved, the court still has to protect the public. And that's exactly why judges can order evaluations or just deny bond straight out. I mean, it is sad, but it's also necessary in some situations like this one. Anyways, guys, I'm going to wrap it up here. Let me know in the comments what you thought about this sovereign citizen here. Thank you again for watching and take